Hello, everyone. Thank you for joining us today. We're going to get started. First, please make sure you get yourself some food. On the table as you enter, there's copies of the comment that was written by Wintana and Jeremy, so please feel free to take a copy for yourself. Once again, thank you to everyone for joining us. We're going to get started, as I mentioned. The round of thanks, which are necessary. Can't thank everyone. And I know when I start naming names, I'm going to exclude someone. I don't mean to do that. But thank you to Dean Celorio. Thank you to Professor Calabro. Thank you to our friends in the Media Center for setting it all up today. A lot of things have to happen for us to be able to meet this way. My name is Alberto Benítez, along with my colleague, Professor Vera, who's seated in front. We co-direct the Immigration Clinic, and in the fall semester day, I teach a section of Immigration Law 1. I'm the proud son of Mexican immigrants. I grew up in a Mexican immigrant community, although I never really recognized it as such. It was just the friends of the family that we used to hang out with. And it wasn't until 1984 that I learned about this thing known as immigration law as a field, and that was after my first year of law school. Those of you, I think I'm the only person in this room that was alive in 1984. But no, you were not alive in 1984. Ronald Reagan was president of the United States at that point, and from 1984 to the present, there have been administrations from both political parties. Both political parties have done great things for immigration. Both political parties have done things that are bad for immigration. One caveat, the prior administration probably took it to an all-time low in terms of doing bad things for immigration. But other than that, I just want to share with you that in 1986, President Ronald Reagan signed a sweeping legalization bill in which millions of people who were out of status got green cards, a conservative Republican. And 10 years later, President Bill Clinton, a progressive Democrat, signed probably the most restrictive immigration law in history, the Illegal Immigration Reform and Immigrant Responsibility Act. So immigration policy and procedure doesn't follow a narrow line. Both political parties don't have clean hands when it comes to it. However, I think one of the things that makes the GW Immigration Clinic the special place that it is that we compliment our government when it does well, but we criticize our government when it can do better. And today's topic is going to be what has become known as the Asylum Transit Ban, which is a proposed rule that the current administration is trying to promulgate to make it harder to apply for asylum. We have two distinguished GW law students who are also student attorneys in the Immigration Clinic who are going to tell you all about it and talk about their comment that they filed on Monday, I believe it was. And they told Professor Ben and myself earlier today that there were 52,000 comments filed during the notice and comment period. Undoubtedly, Wintana and Jeremy's comment was the best. That's the one that's going to influence Secretary Mayorkas, himself an immigrant to the country. So Secretary Mayorkas should know better than to be trying to make it harder to apply for asylum. We compliment and we criticize equally. Wintana Yohannes is a third-year law student serving clients in the Immigration Clinic. She is a native of Abu Dhabi, UAE, a proud immigrant of Eritrean descent, and a deferred action for childhood arrivals, DACA, recipient. Before law school, Wintana taught 9th grade English via Teach for America in Boston, and subsequently joined TFA's DACA Advisory Board as a volunteer board member. In this role, she designed and facilitated supporting undocumented students' training sessions equipping over 7,000 core members with the tools to support and advocate for undocumented students nationwide. Wintana holds a bachelor's degree from the University of Virginia and a master's degree in education from Boston University. Wintana, thank you. Jeremy Reiner is a second-year law student and a student attorney in the Immigration Clinic, a native of Northern California and a graduate of the University of Texas at Dallas. He has advocated for policies supporting immigrants' rights to a half dozen congressional offices with the International Refugee Assistance Project, IRAP. This year, he is serving as policy director for IRAP's GW Law chapter. Thank you, Jeremy. Professor Red and I mooted Wintana and Jeremy twice, and they survived the moots with us. So what we have asked Wintana and Jeremy to do is to speak each for about 10 minutes, and then open it up for questions. So we hope you have lots of questions. Don't forget to get some food, and thank you very much. I turn it over to the stars of the show, Wintana and Jeremy. Thank you.
Hi everyone, thanks for being here. We're excited to talk to you about the Biden administration's proposed rule, the rebuttable presumption it applies, why that's more of a ban, and why it's so important that the Biden administration doesn't enact this proposed rule. So I'll give a brief overview of some US asylum history, and then I'll go into a little overview of the proposed rule and how difficult it is to overcome the rebuttable presumption. And then my colleague Wintana will go into more of the specifics of the 3 exceptions to the rule and why they don't provide realistic opportunities for asylum seekers, and then go into some ancillary issues, and then wrap up with how this rule is best understood as a continuation of the previous administration's policies relating to immigration. So to start off with a brief bit of history, most of our U.S. asylum law comes from the UN Refugee Protocol from 1967. So it established the definition of a refugee as someone that's outside of their country due to a well-founded fear of persecution in that country based on one of 5 protected classes, those being race, religion, nationality, membership in a particular social group, or political opinion. And the protocol also established 2 important principles for how nations are allowed to treat their asylum seekers, their refugees. And so the first one is non-refoulement, which stands for the principle that a country can't send an asylum seeker or refugee back to the country where they have a fear of persecution. And the second principle is non-penalization, which is to say that a country can't penalize an asylum seeker for the method of how they got to the country where they're seeking protection, and importantly, whether or not they broke any sort of immigration laws to get there, to seek those protections. And so in the US, the Refugee Act of 1980 incorporated most of that language and those principles. So the statutory language, which isn't the language that I typically use, but what they say is any alien, irrespective of their status, may apply for asylum. So in other words, it's an absolute right once someone has reached the soil of this country or a port of entry, then they may apply for asylum. So the last administration, as you probably know, had a number of restrictions on asylum and immigration in general. One of the biggest ones is Title 42, and that expanded something known as expedited removal, which is a process where even a lower ranking immigration official, like an asylum officer, can order non-citizens removed in a very quick process that only takes a couple of days. And in this way, the non-citizen would never get to be in front of an immigration judge and have a fair chance at adjudicating their asylum case. Another policy that the previous administration made was the Migrant Protection Protocols, also known as Remain in Mexico, which is a policy that led to many people being sent back to Mexico after having tried to apply for asylum in the US. And so at this point, I'd like to note that the being sent to another country while one's asylum case is adjudicated, like the Remain in Mexico program, sounds like not too onerous a burden. However, the asylum process is very slow in this country. For instance, one of my clients crossed the border into this country seeking asylum in January of 2016, and later this month, she has a hearing to start that adjudicating process. So it can be a very long time that people will wait for their asylum case to be adjudicated. And you can see with these policies that there's some conflict clearly between the principle of non-refoulement and these policies, because people, even if they have a fear of persecution in Mexico, we're still being sent back to Mexico. So now just to give a brief overview of the proposed rule, it was put into the Federal Register with notice and comment procedures, which if you haven't taken admin law last semester, then you may not be familiar with, but that's the process by which an agency puts a proposed regulation up for public comment, and anyone can comment on it, and that's how Wintana and I made our comment on it. So the proposed rule puts a rebuttable presumption of ineligibility for asylum for anyone who comes across our southern border. So in other words, they will be presumed to be ineligible completely for asylum, regardless of whether they meet the statutory eligibility requirements for asylum in US law. So there are three small exceptions, which are three administrative pathways by which asylum seekers can make the rebuttable presumption not apply to them. But they don't provide a realistic opportunity for these asylum seekers to have their cases fairly adjudicated. And in a couple minutes, my colleague Wintana will go into those exceptions in depth and show exactly why they don't provide an opportunity. Another thing the proposed rule does is it uses enhanced expedited removal, where again, people, before they can get their cases fairly adjudicated before an immigration judge or other sort of officer, they can get removed in just a matter of days. And so, again, we can see the conflicts between these policies and those principles from the UN protocol of non-refoulement and non-penalization, because we are clearly penalizing asylum seekers for the manner in which they came to the country, and we might even be sending them back to the country where they have a fear of persecution. So in the absence of asylum protection, or if someone is ineligible for it, there are other forms of relief. However, the bottom line is that these forms of relief are more difficult to qualify for compared to asylum. They have a higher bar, and they also provide much fewer benefits than asylum does. So principally, neither the Convention Against Torture or withholding of removal provide a path to citizenship or legal permanent residency. They're purely temporary forms of relief, and there are other problems with them. For instance, that they can be applied to certain members of the family and not others, leading to the family separation issue. And as well, neither of them are a complete protection against removal, as in certain cases with either type of relief, the non-citizen can still be removed from the country. So, given that the proposed rule has a rebuttable presumption, the obvious question is, how is it rebutted? And the answer is that the proposed rule requires that an asylum seeker show that they are facing imminent and extreme threats to life and safety. Now, that is a very, very high bar, much higher, again, than the requirements for asylum eligibility. So effectively, this creates impossible documentary requirements for asylum seekers to have to prove that they not only satisfy the eligibility requirements for asylum itself, but also for this much higher bar of the imminent and extreme threat. So in this case, to go back to the example of my client who came over here in 2016. She's a native of El Salvador, and after her brother switched gang allegiances, the MS-18 gang brutally murdered her brother and had a vendetta against her and her family. They robbed them, harassed them, and sexually harassed my client to the point where she attempted suicide multiple times before finally leaving and coming to the US. So while her persecution that she suffered is clear, it's obvious, it's very likely that she would not be able to have her case fairly adjudicated if this proposed rule had been in effect, because it's very difficult to prove that those threats that she faced in El Salvador she still continues to face them as she comes to our southern border. She would have to provide evidence, whether through documents or through her own testimony, that those threats still are facing her as she comes to the border, and that is simply is nearly impossible. Most of these forms of persecution, as my client suffered, don't produce documents and the sort of notarized evidence that will clearly convince anyone. So they are stuck with their own testimony to try to convince the asylum officer not only that they qualify for asylum, but that they qualify for overcoming this very high evidentiary bar. So in other words, we're putting these asylum seekers up to the gun of discretion roulette, where they have to rely on their luck in terms of getting a sympathetic ear in an asylum officer, not only to prove that they're eligible for asylum, but also that they have these imminent and extreme threats, which is, again, an extremely high bar. And so the end result is inevitably that many meritorious claims, people that do deserve asylum, that have faced persecution, will, regardless, be rejected from receiving any sort of asylum protections simply because they can't satisfy this extra high evidentiary bar, which again is not connected to the requirements for asylum eligibility. So now I'll turn this over to my colleague Wintana to go into the details of the rule.
Okay, so as my colleague Jeremy stated, the proposed rule outlines 3 lawful pathways by which asylum seekers may seek asylum at the southern border. The first pathway applies only to nationals of Venezuela, Nicaragua, Haiti, and Cuba, and allows these migrants to enter and remain in the United States for a period of 2 years under what is known as a parole status. Now, this program was initially introduced in October 2022 by the Biden administration as part of what it called the Venezuela Initiative, which was introduced to stem the flow of Venezuelan migrants at the southern border. Because the initiative was really successful in that it led to a 67% decline in the number of Venezuelans encountered at the southern border, the Biden administration in January elected to expand this program to now include Nicaragua, Haiti, and Cuba. So what does this program actually entail? I think first it's important to note that this parole process actually is an expansion of the lawful pathways by which these nationals may seek asylum in the United States, so that is a win. More specifically, the parole program allows up to 30,000 individuals across these 4 countries to apply for parole per month. It does require individuals from these countries seeking parole to have an eligible US sponsor who can essentially demonstrate that they can provide financial support for up to 2 years. It also requires individuals seeking parole to pass a background check, and if all these requirements are satisfied, the parole is granted and work authorization is also provided, and that again is for a period of 2 years. There are some exceptions, however, to this program. So individuals from these nations who do not qualify are those who have crossed the US, Panama, or Mexico border on the date or after this announcement, which again was in January of this year. And because this program was announced in partnership with Mexico, it essentially allows the United States government to deport up to 30,000 individuals who are ineligible for this program back to Mexico per month. One thing I want to note here is that our public comment does not discuss this program in detail, and although there are criticisms associated with the program, one reason we limited our discussion is because it is in fact an expansion of the lawful pathways to the US. Instead, I want to turn your attention now to the two remaining pathways outlined by this proposed rule, which effectively serve as a ban on asylum. So the second pathway allows migrants to make an appointment to appear at a port of entry at the southern border. And that is via an app called the CBP One app, which is only available on smartphones for download in English and Spanish. To make an appointment at a port of entry using this app, migrants have to do two things. First, they have to input their information, their biographical information into the app. Second, they then have to use the app's photo capture function to essentially take a selfie in what is known as a liveness check to confirm that it is in fact a live person who's attempting to make this appointment. So if those two things are completed, the idea is that the migrant can essentially then proceed to making an appointment. This proposal is based on extremely limited data. In the proposed regulation, the Department of Homeland Security cites a survey that was conducted by CBP officers on December 11, 2022 at two ports in Texas, in which CBP officers concluded that between 93 to 95% of migrants crossing the two ports of entry on that one particular day did in fact have a smartphone in their possession. The Biden administration here argues that this app will create efficiencies, the idea being that if migrants are inputting their information into the app in advance, it will lead to quicker processing times and shorter wait lines at the southern border. However, since this app launched in January, advocates and migrants have noted numerous issues. For example, the app's photo capture function struggles to recognize individuals with darker skin tones, meaning that if these individuals aren't recognized as live beings, they cannot then proceed to making an appointment to appear at a port of entry. The app has also been plagued with glitches. Numerous individuals have reported error messages popping up as they attempt to input their information. You yourselves can take a look at the App Store and read the numerous comments that have been submitted. The app also presents issues in that there's very limited information about the number of available appointments. Additional issues concern the lack of charging stations and the poor wireless connectivity that may make it difficult for individuals to actually access this app to make that appointment. But I think most of all, what is problematic about this pathway is that it does require migrants to have a phone that can support this technology. In our public comment, we spoke with our clients and highlighted their stories to make the point that if this proposed rule was in effect when they crossed the border, they would have in fact been ineligible because they did not have a fully functioning smartphone in their possession. And although the rule outlines some exceptions for those who may be illiterate or those who face language barriers, the question becomes, how do these individuals demonstrate by a preponderance of the evidence that they in fact had trouble using that app? So I think given the issues I laid out, we believe and advocates have argued that this pathway will ultimately lead asylum seekers to be removed, even in the event that they have a meritorious claim for asylum. The third pathway outlined by this rule requires or allows migrants to seek asylum in the United States only if they have sought asylum and been denied asylum in a third country through which they traveled on their way to the United States. And there are two main issues with this pathway. First, it presumes that migrants who have extremely limited resources can afford to wait for months in a third country while their application is being processed. In some instances, for example, in Mexico, it may take up to 1 year for an asylum application to be processed. The second issue with this rule is that, or this pathway, is that it fails to acknowledge the numerous reports and studies that have been published, especially in recent years, that detail the discrimination and other harms that migrants have faced in these third countries, especially in Mexico, on their way to the US. Those harms include kidnapping, violence, sexual violence, and homelessness. To illustrate the harms that migrants face in these third countries, in our public comment, I told the story of my client from El Salvador who fled her home country because she was persecuted on the basis of her transgender identity and her work as a health rights activist. My client shared with me in particular that during her brief stay in Mexico, she elected not to apply for asylum, and that was because she was made to feel so unwelcome. Specifically, the locals would constantly yell at her and threaten her with violence if she did not leave. She was also called many derogatory terms on the basis of her transgender identity. I think my client's story is very emblematic of the traumatic experiences that these migrants normally face in these third countries they travel through. And this begs the question, why the administration would propose such a rule if it means that a migrant might have to further expose themselves to harms just to seek access to the United States. Some ancillary issues regarding the rule concern the condensed announcement to rollout timeframe. Two main points here. So first, you can see on your screen that the public comment period closed on March 27. The public comment period was open for just 30 days, and that is in contrast to the general understanding that 60 days are required to provide the public with a full opportunity to make a meaningful comment on the rule. Aside from the brief public comment period, you can see here that on May 11, the public health emergency is set to end, which means that Title 42 is expected to be lifted. This timeline provides DHS with just under 6 weeks to review the nearly 52,000 comments that were submitted and announce the proposed rule. The main concern here is that this condensed announcement to rollout timeframe is going to lead to confusion both on the part of migrants who may be traveling to our southern border, who may be unaware of what our current regulations and laws are, but also on the part of CBP officers who may not know how to interpret such a rule given the rushed rollout. Now, our flyer for this event posed the question, is President Biden's proposed rule a continuation of Trump-era immigration policies? I think most, if not all of us in this room can recall that during former President Trump's tenure in office, we witnessed multiple attacks on our asylum system, right? With just a snapshot of the regulations and rules that were rolled out during his 4 years in office. And although the Biden administration's immigration policies have not been as chaotic in their rollout or disastrous in their impact, it's hard to argue that this proposed rule isn't a repackaging of some of the Trump-era immigration policies simply presented as innovative solutions to tackling the flow of migrants at the southern border. So I want to conclude with just noting that this proposed rule is also a reversal of the commitments President Biden made while he was on the campaign trail. On the campaign trail, he introduced his immigration plan, and specifically in his 100-day plan of action, noted his commitment to asylum seekers and refugees. Now, in his 2 years in office, we've seen him walk back this commitment, but we've also seen him respond positively to pushback from lawmakers and members of the public. And so it is our hope in submitting our public comment that DHS does review the thousands of comments submitted and does in fact opt to fully restore our asylum system on May 11 when Title 42 is lifted. So with that, we are happy to take your questions.
Okay, well, thank you, Jeremy and Wintana. Great job. I think now we're going to move to questions. So we actually have a nice microphone. So who has questions? You're all law students. I know you have questions. Cornelia has a question. And Cornelia, can you pass the mic on to whoever has questions after that?
Okay, so my question is pretty quick. Ooh, I'm on the mic. Okay. So I know that you mentioned that migrants coming in will need the app on their phone in order to get an appointment. Is there anything in place for those who do not have a phone or have the app? Like, how would they get an appointment? How would they see someone?
So great question. Can you all hear me? Okay. So the app allows for individuals to make an appointment at a port of entry. There are exclusions. So the two named exclusions include those who are illiterate and those who may be experiencing language barriers. So one concern there may be that because this app is only available in English and Spanish, you might have someone who isn't, does not speak that language, who may attempt to access it, who may be exempted. So yes, there are exemptions. However, to Jeremy's point about the condition that will be placed on their application for asylum as part of that rebuttable presumption, the burden then shifts to the individual to prove by a preponderance of the evidence that they did in fact have trouble accessing that app. And if they cannot overcome that burden, the credible fear, which is a 10% threshold, is then converted to a reasonable fear at a 50% threshold, making it that much more difficult to seek asylum in the country.
Thank you. Anyone else have any questions?
Hello, thank you so much. I have a question in terms of other nationalities, because I know at the border, they're not only people from these countries you listed there. So what is the rule for those? And what about Afghanistan and Ukraine?
Speak for the podium.
So that's an excellent question. To clarify, this rule only applies to those individuals who are seeking asylum at the southern border, not necessarily those who fly in. So to your question, aside from pathway number 1, which applies to nationals from these 4 countries listed, if this proposed rule does in fact go into effect, it would limit the remaining options that individuals who are not from these nations have to access the system.
I see.
Does that answer your question?
Not really, because I know that a lot of countries, even if they, in case of those countries I mentioned, they go to the border as well. So I wanted to know if they have an exception, because I know they had an exception for country, they received X numbers of Afghan refugees or Ukraine, but I know that at the border, those are not the only nationalities that go there.
No, you're correct. So if in fact you have someone from Ukraine or Afghanistan attempting to enter the southern border, if this rule does go into effect on May 11, their options would essentially be pathway number 2 or pathway number 3.
Thanks.
Sure. Jeremy, do you want to join me up here? Or are you okay there?
Anyone else has a question?
Hi again. So my question is, this excludes people who enter through Panama, the US, and Mexico. Do you know why Panama is included in that?
I don't have an answer to that question, but I do know it only excludes nationals from these 4 countries who travel through that border.
I'll work on it. I'm actually working on getting my cedula because I am Panamanian. So I just I need to make sure I'm asking all the right questions before I do something maybe I shouldn't. It's on now.
Thank you. My question is, sorry, how do I say this? The rule establishes a rebuttable presumption, right? So if the person can't meet these 3 requirements, they have to basically show by preponderance of the evidence why, or the extenuating circumstances, etc. Does the proposed rule provide any guidance on how they'll what type of evidence is accepted, or how to meet that bar? And I was reading the letter that was written to the secretary, and it talks about how people often don't have, or maybe it was the other document, one of the 2, but it talks about how people often at this stage don't have legal assistance, and how can they manage this very legalistic process by themselves, and with this higher bar to meet.
So, as with all of our asylum rules, the the individual can just prove their case through their testimony alone. However, it's of course much more difficult to do that, and then you run into the problem of the believability of your story, because if everyone has the same sort of story, it's less likely to be believed. There's some specific guidelines they give for overcoming some of the pathways. For instance, in terms of the app, the documentation you can show is that you have some sort of extenuating circumstance relating to the technology or relating to your language abilities, but they don't provide guidance on how to overcome the rebuttable presumption itself and how to prove that you have an imminent and extreme threat.
Thank you.
Regarding the legal assistance.
So I just want to provide some follow-up. Quick search. So what I'm reading is that a lot of people are coming to Panama because it's sometimes quicker for them to get to Panama than it is for them to get to Mexico. And when they come to Panama, that's like their first encounter with the U.S. immigration. So I'm thinking that's why they're saying no. So I just wanted to put that out there. So they're trying to go, they're basically crossing through land, they're crossing through the jungle. If you've ever been to Panama, it's a lot down there. So to let you guys know that the U.S. is trying to control, I guess, the influx on different, I guess, land masses. So if they can't go to Mexico, they'll go to Panama instead because it's closer.
Thank you.
Can you address the question about the legal
Oh,
representation?
yeah, and to follow up with the second part of your question in the back about legal assistance, it's true that most people likely don't have the legal assistance to go through these processes, and well, that does speak to just how inaccessible the system can be in general for filling out the required paperwork and all that. It's it's a very obtuse system that isn't easily accessible by normal people. We have a question for that.
I can just project. My question is about noun refoulement. So you might not have the answer to this question, but I was just wondering if this proposed rule passes and is implemented, do you think that the United States would be internationally liable for shirking their duties to avoid non-refoulement?
That's a very good question, but there have been other U.S. policies that at least arguably and to plain English do run afoul of non-refoulement, and so I'm not sure about that, but I doubt, just based on the U.S.'s sort of place in the UN, that there would really be any measures taken about that.
Any other questions?
Does anyone else have any questions for our panelists? No? Not even about the work that they're doing, the clients that they mentioned, their comment, nothing? Wow, I'm surprised.
I have, I'm gonna take, I'll ask a question.
Sorry. That's like 5 seconds later than I should have been.
I just have a question about the transgender client that you mentioned, feeling really unsafe and having a really negative experience in Mexico. And I wondered if you could share which region they were in by chance. Because I just want to put it out there so that people don't walk out of here with a really negative idea of Mexico. There are some really great parts that are very LGBTQ friendly, many of which probably even much more than the US. So I just want some clarification on that, please.
Yes, great question. So the region is Tabasco, Mexico, and I believe one of the issues relating to pathway number 3 is that if an individual is seeking asylum in Mexico through the agency known as COMAR, C-O-M-A-R, one of the requirements is that they have to remain in that state through which they enter. And so the issue with my client was that because she faced discrimination and other harms while in Tabasco and had to remain in that region if she did in fact seek to apply for asylum, she didn't feel comfortable and elected to leave to the US. But I appreciate the point that you made, so thank you for that.
I feel very defensive.
Any other questions? Any other questions? I have a question. Can you bring up that standard again about imminent? In your opinion, what does imminent and extreme threat mean?
I probably could find some cases on this, but in general, imminent tends to mean that the harm is not only, it's more than just near, it's very, very near. So in general, imminence is a pretty high bar for, in terms of like the temporal dimension of it. It has to be that it's very recent or will be happening in the very near future.
Wintana, do you have thoughts?
I would agree, but I also think one of the issues here is that the phrasing is pretty vague. And this ties back to some of the ancillary issues that I discussed regarding the condensed announcement to roll out timeframe, just given that this is vague. And if the administration decides to proceed to implement this rule, I think it's very easy to see how CBP officers down at the border might have trouble implementing or discerning what this phrase might mean.
And my memory is, if I could follow up for both of your clients, neither one of them, I think, would satisfy the imminent part of that standard because there was some distance in time between the persecution that they suffered and when they presented themselves to U.S. authorities. Is that correct?
Mm-hmm. That's right. And that does speak to why the requirement to show that the threat is imminent runs afoul of the non-penalization principle, because in effect it's just penalizing people for the method of how they reached the country to seek protection, and even though the persecution they suffered was before.
Okay, well, thank you. Are there any other questions? Oh, Cornelia has a question.
I'm sorry,
Oh, cool. I like questions. We love questions.
So I know that when you mentioned the time frame for the implementation of the rule, you mentioned confusion at the border, but I was wondering what consequences do you guys think will take place if this actual rule is put into effect? What's the consequences on the CBP officers, individuals trying to get into the country, families, what's gonna happen? What you think is gonna happen?
Yeah, I think if it is rolled out in this rush timeline, migrants who are crossing and are unaware of the new rules may be precluded and have that condition placed on their application. And then I think on the part of the CBP officers, you might find that because there is a lack of clarity as to the regulations, you may have CBP agents turn people away. So I think at the end of the day, one thing that we argued in our public comment was that although the administration introduced this rule and the various pathways to stem the flow of migrants, it's going to do the opposite, right? Because we have individuals who are reaching our southern border who have suffered persecution and don't have the luxury of time to be able to remain in their country while they're invited to apply for asylum. And so ultimately this rule, if enacted as is, will not stem the flow of migrants and may lead to additional confusion. Giving it all step.
Yeah, that's a point we made, that the fact that it's so unclear, and well, first for the CBP officers, they'll be applying different standards that they're not used to applying. So again, that'll probably lead to meritorious claims being rejected. But also in terms of the incentive approach, because part of the proposed rule is saying that it would disincentivize people from taking using coyotes or other methods of getting to the border, but if people have to choose between the persecution they're facing, and it very well could be life and death, versus maybe reduced chance of receiving asylum protections, that's still a better chance than, remaining in their home country with that persecution.
So if their claim is rejected, what options do the non-citizens have from there?
So if the rebuttable presumption is placed on their application, essentially the credible fear interview, which is just that 10% chance that you will be persecuted if you return to your home country, is converted from a credible fear interview to a reasonable fear interview, meaning that now there has to be a 50% chance that you may suffer persecution if you are in fact returned to your home country. So given that high bar at 50%, the remaining options that an individual may likely be left with, as Jeremy discussed, are Convention Against Torture and withholding of removal, neither of which provide a permanent pathway to legal status here in the US. So just very detrimental overall. Yes?
Sorry, just to follow up, if they don't want to pursue either one of those, can they appeal their asylum case or their credible fear interview?
That is a great question. Did you have an answer?
Well, I believe that the usual asylum appeal processes apply, and that they can have their denial appealed, but of course that's going to be a long time, and it's not a very immediate form of relief. And I also believe that if someone subject to the rebuttable presumption is removed from the country pursuant to that, I believe that they face a 5-year bar on re-entry.
Thank you.
Hi, I have a question.
You just have to hold it until it lights up again. Hold the button. There it is.
Okay. Hi, I have a question. We know that Title 42 it's about to end. And how do you think that this action will be a benefit or not for the asylum seekers?
So great question. I think if it is enacted, well, I guess I should take a step back. So pathway number 1 was rolled out in January of this year, right? So that expands the asylum processes for individuals of these 4 nations here. Aside from that, I think if the proposed rule is enacted as is, it definitely will have a detrimental effect, as we talked about a few minutes ago, just in terms of precluding individuals who may not have had any sort of awareness about these potential pathways, which are now severely restricted, which may now be severely restricted.
And part of the proposed rule, part of the justification for it is to address what the administration believes will be, an increase in the humanitarian emergencies going down at our southern border. So in the absence of Title 42 and the proposed rule, I'm not sure what would happen, although I think that expedited removal would be less used, less effective in that way. So in that way, it would be easier for asylum seekers to have their cases fairly adjudicated.
I don't have a question per se. If anyone has any other questions. No. So I just want to take this opportunity to let everyone know that we've recently, and if this is okay, I hope I'm not like encroaching, that we've recently relaunched the GW Latinx Law Brief. And if you're interested in this type of issue and topic, it's like, especially, it's the type of article that you can publish about. So I have some flyers, so I'll leave some by the exit if you want to like grab one and know more about the requirements to publish.
Any other questions for Jeremy and Wintana? Wonderful questions. Any other questions?